So let's go ahead and get started. So online platforms, we know that they're popular. Everybody has seen them. What should you be aware of? So we're going to start out with who is right for online planning. I mean, is your situation the correct kind of situation? So sometimes it's easier to start out with saying, well, who is not right for an online planning situation? First of all, are you married? That might be a situation where online planning is not right for you because there is so much that goes into planning for married persons. Do you have minor children? If you have minor children, again, if you don't get the right estate planning advice, you could be putting your kids at risk if something happens to you. Are you in a blended family? Blended families are really a situation where there could be problems if you do online estate planning. So what you can see, what I'm saying is, here are the people that might need more than just online planning because their situation is more complicated. What's the amount and level of your assets? If you have modest assets, you're more likely to be okay with online estate planning. If you have complicated assets in more than one state, if they're a higher level of assets, then you might want to get professional guidance. Who are your intended beneficiaries and what is your relationship with them? Do you have a special needs child or a special needs person who would be inheriting from you? Or do you have somebody who will inherit from you and they do need some sort of asset protection? For example, they couldn't manage their own money, they shouldn't manage their own money. They might be getting government benefits. If they inherit, they will lose all of their benefits. If so, again, online might not be right for you. Do you want some level of control after you're gone? In that perhaps you want to make sure your child inherits, but not your child and a divorcing spouse of your child, not an in-law. What about if you know your family dynamics are problematic, such that if you don't do everything perfectly right, then there could be litigation or problems. So all of these situations are situations where think twice about online estate planning. Yes, you can do cheap, do-it-yourself online estate planning, even in those situations, but the result might mean costs and litigation or problems that your family goes through, or loss of government benefits. This is what I'm talking about. What are the consequences of not getting good estate planning counsel up front? We will talk about, I mentioned married couples. I do want to mention, when I say asset protection for married couples, and remember, I'm coming to you talking from the state of Washington. In Washington, our laws are really clear that if you want to protect assets for your spouse when you're gone against any kind of spend down for long-term care costs, the only way you can do it is through a will. Yes, you can buy an online will, but no, an online will not have the correct type of trust in it to protect assets for your spouse. And that's why I said that if you are married, and especially if you're interested in asset protection, online planning might be a real disservice for you. You might want to see a lawyer. Along those lines, if you are a retiree, again, this goes back to asset protection. People who are retired, generally they're older. Generally, folks who are older may have concerns about protecting assets that they have against long-term care costs, not just for their spouse, but maybe for themselves. Part of online estate planning is not just a will, but probably a durable power of attorney, because everybody needs a durable power of attorney no matter what, one for finances and one for health or medical. So if you do an online durable power of attorney, and let's say something happens to you in the future, you want to protect assets for yourself so that everything you worked for all your life doesn't have to be spent down on your long-term care costs. Would you be able to do any kind of Medicaid planning? Well, if you're incapacitated and you have an online durable power of attorney, one that doesn't grant the necessary authorities for your attorney in fact, your POA, to do the kind of planning that needs to be done, then no, you won't be able to do any type of Medicaid strategies. That means all of your assets will be spent on long-term care. So retirees are folks that I really encourage to speak with an attorney, an elder law attorney that knows Medicaid asset preservation strategies. Takeaway on that was all of those folks think twice about doing online. So who is online possibly okay for? Who might it work for? Are you single? Do you have no minor children? You can have kids, just not minors. Are your assets fairly simple and modest? If that's the situation, then online estate planning might work for you. One of the things that you don't get from online estate planning though, is let's say you fit that bill. You're single, you have no minor kids, you haven't been divorced, at least not recently. It's been ages ago, so you're not worried about your divorcing spouse claiming anything. You have modest assets. And so you think, well, let's just do an online estate plan. What might not happen is that you might not become aware of estate planning strategies that would allow your estate to be administered simply upon your death. So for example, if you do a will takes effect upon your death. What do I mean it takes effect? Well, that's when your will needs to be probated. Probate is an expense that an online estate planning form will not help you with. So if you're doing an online estate plan for cheap, then you are deferring the expenses of administering your estate until after you've died. So you do want to make sure that you have money set aside to help with the probate of your estate. So let's say you're single, you do an online will, and you own a house, and you just want everything to go to your child or your two kids equally. And so you fill out the online form. Had you come to an estate planning attorney such as myself, I might have suggested to you, well, of course you do need a will, but let's make sure you avoid probate because we don't want to have an unnecessary probate upon your death. Let's go ahead and do a transfer on death deed on your house. And if you do that, you will then avoid the costs of a probate when you die. If we get it set up right, then yes, you pay costs to the attorney when you set up your estate plan, but upon your death, there's virtually no costs. Whereas if you did it on an online platform without getting guidance and counsel, then yeah, it was cheap up front, but there will be significantly more costs on your death. And so that's the kind of situation where, with online forms, you might get a perfectly correct form for the state you're in, but you will not get guidance as to, well, what does that mean for the rest of your life and for upon your death? Kind of the takeaway is a single person with modest assets, no minor children, may be appropriate for an online type estate planning package. And then now what we're going to do is we will get into, okay, so what should you be looking for then if you're doing an online package? Question, is the takeaway that everyone is better suited to do a consult with an attorney, even if they qualify for doing online forms? Yes. Yeah, that really is the takeaway. And granted, I'm an estate planning attorney. What I do is I help guide people. So I know that if you were to talk with me or another estate planning lawyer, you're going to get advice. Whereas even if you do one of those online form packages, I think there's packages that you can buy for $500, and it includes a consultation with an attorney. I think you have to question, what are you really getting for that $500? Are you really getting somebody who is going to take the time needed to know your situation and give you the right plan? Or are you just going to get a cookie cutter package that is what is sold with all of those plans? Let's move on to, okay, let's say you have decided, or at least you're interested in doing the online planning. So if that's the route you're going to take, then what do you need to know to have your best opportunity at doing it right. Number one, make sure that the forms that you are using are state-specific forms. And what I mean by that is if you live in Illinois, for example, you are not going to want to have a form filled out that says Washington or Washington law. That's kind of a obvious situation, an obvious problem. But do make sure that when you fill out the forms that they are appropriate for your state. One of the things I wanted to mention though is any legal document that is filled out correctly in one state will be honored theoretically, legally in another state. That means that, if you filled it out in Washington, for example, you filled out the right Washington form, you put in Washington law, Washington, everything specific. You filled it out. And then what happens? Let's say you move to a different state. In Washington, our probates are really simple. So typically estate planning done in Washington is based on last wills as opposed to revocable living trusts for a lot of reasons. Our probates are simple here. There's a lot of problems with revocable living trusts if they're not administered correctly. So let's say you fill out your online form and under the laws of Washington, and it's all done correctly, and then you move to California, for example. So when you move to California, your Washington forms filled out correctly here will be legally enforceable in California. Will that be the right plan for you in California? So every state has its own different version of what durable powers of attorney look like. So your durable power of attorney might be legally effective in California, but there might be difficulty in having it accepted by a financial institution. More importantly, your Washington will work fine here in Washington, and in California, it will be recognized, it will be honored. But in California, probates are extremely expensive. They're based on a percentage of the value of your estate. And that's why in California, because probate is so expensive, if you don't visit an estate planning lawyer and don't create a different kind of estate plan, for example, like a revocable living trust-based plan in California, then the result is going to be a lot of costs for your estate when you have passed on. So it may be technically legal enforceable in one state, an online form, but it might be a terrible plan in a different state. And how do you know that? You don't know that unless you talk to an attorney.